NSA leaker Edward Snowden remains on the lam, but the FBI is working to track his digital trail, even as his physical trail appears to have gone cold. Edward Snowden's last known address was a hotel in Hong Kong, but since he checked out on Monday, investigators don't know where he went. But the UK's Guardian says he's thought to be in a safe house. Now, here's a new piece of his life that we now do know. Take a look. His girlfriend, the one he left behind back in the U.S., a 28-year-old named Lindsay Mills, and Mills's father had this to say about Snowden.
He's always had strong convictions of right and wrong, and it kind of makes sense, but still shocked.
The head of the National Security Agency is going to be back on the Hill today. This time, Army General Keith Alexander will face some tough questions from the Senate. Senator Ron Wyden, the head of the Intelligence Committee, is calling for public hearings. He and 7 other senators also introducing legislation that could partially lift the veil.
It's not possible for the Congress to do the kind of vigorous oversight that the president spoke about if you can't get straight answers.
The ACLU, meanwhile, has filed suit against the Director of National Intelligence. They claim the secret surveillance, giving, quote, the government a comprehensive record of our associations and public movements, revealing a wealth of detail about our familial, political, professional, religious, and intimate associations. And then 3 tech giants, Google, Microsoft, and Facebook, are seeking permission to publicly disclose the requests for information that they've received from Uncle Sam. A lot of moving parts and a lot to catch you up on. But joining me right now is Jamil Jaffer, Deputy Legal Director with the ACLU. Jamil, it's great to have you with me. And let's take a look at what the lawsuit is claiming. Basic violations of free speech, privacy, and that the NSA spying exceeds authority Congress provided under the Patriot Act. Now, the ACLU is claiming that these programs are the equivalent of requiring every American to file a daily report with the government. And we've seen similar cases dismissed on the basis that they would reveal state secrets or because plaintiffs could not prove that they had been monitored in the first place. So explain to all of us what makes this case so different.
Sure. Well, one thing that makes it different is that the government has now acknowledged the existence of this surveillance program. It's acknowledged that it required Verizon in particular to turn over 3 months' worth of call data relating to all of its subscribers. So there's no question that the surveillance program is going on, still going on now, has been going on for 7 years at least. The other thing that makes it different is we, the plaintiffs here, the ACLU, can show that our own communications have been monitored because the ACLU is a Verizon subscriber. And so, you know, the 2 problems, as you noted, that have been issues in other surveillance cases have been secrecy and standing. Neither of those, at least on the surface, seems to be a problem here because the plaintiffs can show that their own communications were monitored under a program that the government itself has acknowledged.
All right, so we talk about the government acknowledging this, but Jamil, the government has already defended the legality of this program, saying that Congress has been briefed about the data collection, knowing all the details, and in doing so still reauthorized the so-called business records provision of the Patriot Act. So doesn't it seem like they're already
I guess, you know, I'd say a few different things about that. One is that, you know, Congress can't sanction a violation of the Constitution. Even if Congress had authorized all of this, there's still the question of whether it's constitutional. And that's something for a court to decide, not for Congress. And the second is, many members of Congress dispute this notion that Congress authorized this program, including one of the legislators who was one of the authors of the Patriot Act has said that this is not the kind of thing that Section 215 was meant to authorize. Senator Wyden, who you quoted just a minute ago, has said that this is a program that the law was plainly not meant to authorize. So there's a real question here about whether even the Patriot Act, which obviously has very broad parameters, whether even the Patriot Act authorizes the kind of surveillance program that the government has put in place.
Jamil, Time Magazine's Joe Klein has an opinion piece out today titled "The Civil Liberties Freak Out." He says that far too many people get their notions of what our government is all about from Hollywood. The idea that our government is some sort of conspiracy, that it's somehow foreign body intent on robbing us of our freedoms is corrosive and dangerous to our democracy. Isn't there a time when national security trumps privacy?
You know, this idea that the critics of the program are alleging some kind of conspiracy. I think this is a straw man. Nobody's alleging a conspiracy. What we're alleging is that the National Security Agency is collecting information about every single American's phone calls, and that is something that the president himself has confirmed, so I don't really know what Joe Klein is talking about. But as to your question about national security and civil liberties, absolutely, sometimes there are hard questions, and we have to draw lines, but the problem here is that no line has been drawn. The government is simply collecting everything. And to argue that this strikes a balance between national security and civil liberties, I think is ridiculous. There's no balance at all here. There's nothing in place to protect civil liberties. Everything is collected.
All right, the ACLU's Jamil Jaffer. Jamil, great to have you on today. Thanks for your insight. I appreciate it.
Thank you.
Joining me right now is Montana Senator Jon Tester, a member of the Homeland Security Subcommittee and one of the senators on the secret law Gang of Eight right now. Sir, it's great to have you here. And as we point out, you and 7 fellow senators have introduced a bill that would declassify key opinions of the FISA court, an effort to at least partially lift the veil on the court's secret operations. Some would argue, though, that disclosing the secret operations of the FISA court then compromises national security and the programs that it oversees. How do you respond to that?
Well, I don't agree with that. I think if we're going to have a discussion on the issue of what the FISA court's doing and what NSA is doing, we've got to have information to be able to do that. And I don't think this compromises our security at all. It just brings a little transparency to government. They can redact information if it's information that compromises our national security. So I just think this is an opportunity to shed a little light so we can have a discussion on this. And that's where the problem is. I mean, the problem is we have never had a healthy discussion on what the court's doing and if they're abusing their powers or not. And when I got here 6 years ago, they were talking about targeting. They target the people they're gathering information on. Now we're at a point where they're doing broad sweeps. When did that change, and how come it changed? And we need to have a discussion on that as we move forward.
All right, so sir, as I mentioned earlier, the NSA Director, Army General Keith Alexander, is going to appear today before the Senate Appropriations Committee. But back in March, Director of National Intelligence James Clapper gave an answer during a Senate Intelligence hearing that he now acknowledges wasn't the whole truth about the NSA surveillance program. So what makes you so sure that you'll get straight answers today?
Well, they better give straight answers. I mean, the fact is, if we come back and when we're not getting straight answers, there will be ramifications to that. And so, I mean, that's a concern coming down the court every time you have a hearing. But the fact is, it's not much of a concern on mine. They're testifying before a major committee in the Senate. Truthfulness is if they're not truthful, we've got bigger problems than I think.
And Senator, it's not just the admitted leaker, Edward Snowden, under fire right now. Congressman Peter King says that journalists who published this information should be punished also. Take a listen.
If they willingly knew that this was classified information, I think action should be taken, especially on something of this magnitude. I think something on this magnitude, there is an obligation, both moral but also legal, I believe, against a reporter disclosing something which would so severely compromise national security.
Sir, would you agree with that reporters bear responsibility? And do you think Snowden himself should face prosecution?
The information that they wrote about was just the fact that the NSA was doing broad sweeps of foreign and domestic phone records, metadata. First of all, Snowden probably shouldn't have done what he did, but the fact of the matter is I don't see how that compromises the security of this country whatsoever. And quite frankly, it helps people like me become aware of a situation that I wasn't aware of before, because I don't sit on that intelligence committee. And it allows us to have a debate and hopefully have a debate eventually on the Senate floor about what the FISA court's doing, the criteria they're using to make their decisions, and if it's the right move to make. I mean, I am of a belief that we have to fight terrorism, we have to use the tools we need, but we have to protect our civil liberties too. Freedom is what this country was founded upon, and I think we can do both. But in order to do both, we have to have an honest debate and an honest discussion about this issue.
Senator Jon Tester, sir, great to have you on this morning. Thank you.
Thanks.